Before we begin, it's important to understand that this presentation is for informational and educational purposes only. I am not an attorney or a medical professional, and the content in this video should not be considered legal or medical advice. Always consult with a qualified professional for any health or legal concerns. Imagine you open an envelope from a hospital. Inside is a bill that makes your heart stop. You see a charge for $10,000 for a single aspirin. You see a facility fee for $50,000 for a room you were in for less than an hour. Your mind races. This has to be a mistake. Typo. But then the terrifying reality sinks in. It's not. This isn't a scene from a dystopian movie. It's a scenario that plays out every single day in America. And the only thing standing between you and potential financial ruin, the only rulebook in this chaotic game, is something most of us know almost nothing about: health law. You might hear that term, health law, and your eyes glaze over. Sounds boring, complicated, something for lawyers in expensive suits to worry about. But I'm here to tell you that understanding the basics of health law is one of the most critical survival skills you can have in the 21st century United States. It is the invisible architecture that surrounds every single interaction you have with the healthcare system. It dictates your rights as a patient, what your insurance company can and cannot do, who is liable when something goes horribly wrong, and even what new medicines are allowed to reach you. Ignoring health law is like trying to navigate a minefield blindfolded. Every year, over 250,000 people in the US die from medical errors. That makes it the third leading cause of death, right behind heart disease and cancer. And that's just one statistic. Millions more are impacted by surprise medical bills, insurance denials, and privacy breaches. This isn't just a system with a few cracks. For many people, it feels fundamentally broken. But here's the good news. You don't need a law degree to protect yourself. You just need a roadmap. And that is exactly what this video series is designed to be. This is your crash course, your field guide to the American healthcare maze. We are going to demystify this complex world and arm you with the knowledge you need to become your own best advocate. Over the next 10 parts, we're going to pull back the curtain on the entire system. We'll start with the absolute fundamentals. What even is health law? Where did it come from, and why is the American system so uniquely, and often frustratingly, complex compared to the rest of the world? We'll explore the sacred doctor-patient relationship and uncover the legal duties your doctor owes you, the concepts of consent, confidentiality, and the standard of care. We'll dive deep into the beast itself, health insurance. We'll decode the alphabet soup of HMOs, PPOs, and HSAs. We will uncover the secrets of how to fight a denied claim and win. We'll talk about COBRA, the Affordable Care Act, Medicare, and Medicaid, breaking down who they're for and how they actually work. Then we'll tackle one of the most feared topics in medicine: medical malpractice. What legally constitutes malpractice? How do you prove it? We'll look at real-world cases that change the face of medicine and patient safety forever. We'll also explore your rights as a patient, the rights you probably don't even know you have. We're talking about the right to see your own medical records, the right to a second opinion, and the right to refuse treatment. We'll unpack the landmark privacy law, HIPAA, and explain what it really protects and, more importantly, what it doesn't. But we won't stop there. We'll investigate the powerful government agencies that control our healthcare world, like the FDA, which decides which drugs you can take, and the DEA, which regulates controlled substances. We'll look at the laws governing hospitals and healthcare facilities. Why are they allowed to charge what they charge? What are their obligations during an emergency? And finally, we'll look to the future. We'll explore the Wild West of telehealth, genetic testing, and artificial intelligence in medicine. What are the new legal and ethical dilemmas we're facing? How will the law adapt to a world of wearable health tech and DNA databases? This isn't just an academic exercise. This is about real life. This is about knowing what to do when your insurer says no to a life-saving procedure for your child. It's about understanding your options when a routine surgery goes wrong. It's about protecting your most sensitive personal data in a digital world. It's about taking back control. So, what is health law at its core? Think of it as the official rulebook for a high-stakes game where the prize is your health and financial well-being. It is a massive collection of laws, regulations, and court decisions that govern everything from the moment you call a doctor's office to the final bill you receive. It covers everything from the quality of care you receive, to the privacy of your information, to the cost of your prescriptions. It is a blend of different legal areas: contract law for your insurance policy, tort law for malpractice cases, and administrative law for government regulations. This body of law grew out of a fundamental tension. On one hand, we have the goal of promoting public health, ensuring safe food, clean water, and access to care. On the other hand, we have the deeply American value of individual liberty, the right to make our own choices about our bodies and our lives. Health law is the constant, evolving negotiation between these two powerful forces. Tries to answer incredibly difficult questions. When can the government force someone to be vaccinated for the good of the community? Who gets to decide to end life support? Should a hospital be allowed to turn away a patient who can't pay? The answers to these questions are not simple, and they have been shaped by centuries of debate, tragedy, and scientific breakthrough. They form the very foundation of the system we have today. To truly understand why your insurance works the way it does, or why a hospital has certain procedures, you have to understand the legal framework it's all built upon. It's like trying to understand a building by only looking at the paint color. You have to look at the foundation, the steel beams, the electrical wiring, the hidden structure that holds it all together. That hidden structure is health law, and in this series we're going to give you the blueprints. So let's get started. To understand this massive structure, you can't start from the penthouse suite. You have to go down to the sub-basement, to the very bedrock on which everything is built. Let's start not with the law, but with a person. Let's call her Maria. Maria is driving home from work. It's a Tuesday. She's thinking about what to make for dinner when, out of nowhere, a truck runs a red light. The screech of tires, the violent jolt, and then darkness. She wakes up in an ambulance, lights flashing, a paramedic talking to her. She's rushed into the emergency room of a hospital she's never been to before. She's scared, in pain, and disoriented. And right there, in that moment of absolute chaos and vulnerability, the invisible architecture of American health law surrounds her like a shield. She doesn't see it, she doesn't feel it, but every single thing that happens next is dictated by it. The first and deepest layer of this architecture is the United States Constitution. Now, you might be thinking, what does a 200-year-old document have to do with Maria's car crash? The answer is everything. The Constitution is the ultimate permission slip. It sets the ground rules for what the government can and cannot do. You won't find the word health in the original text, but you will find clauses that have been interpreted over centuries to give the federal government the authority to act in the health sphere. The most powerful of these is the Commerce Clause, which gives Congress the power to regulate commerce among the states. For a long time, healthcare was seen as a purely local issue. A doctor in Ohio treated a patient in Ohio. But as medicine and insurance became national industries, that changed. The drugs Maria is given were likely manufactured in New Jersey, the MRI machine was built in California, and her insurance company is headquartered in Connecticut. Suddenly, her medical care is part of a massive interstate web. The Supreme Court has interpreted the Commerce Clause to mean that if an activity has a substantial effect on interstate commerce, Congress can regulate it. This single clause is the constitutional bedrock for Medicare, Medicaid, the Affordable Care Act, and countless other federal health laws. It's the ultimate source of power. But the Constitution is also a source of limitation. The Bill of Rights, for example, guarantees certain individual liberties, like the right to privacy, which profoundly shapes debates around everything from reproductive rights to the confidentiality of our medical records. This constitutional layer is vast and foundational, the very ground on which the entire hospital stands. Okay, so Maria is in the ER. They don't ask for her insurance card first. They don't ask if she can pay. They immediately begin working to stabilize her. Why? Because of the second layer of health law, statutes. Statutes are the laws written and passed by Congress or your state legislature. They are the steel beams of the building, the big, clear, powerful rules. The reason the hospital has to treat Maria is a federal statute called EMTLA, the Emergency Medical Treatment and Labor Act. Passed in 1986, it essentially says that any hospital that accepts Medicare payments, which is nearly all of them, must provide an appropriate medical screening to anyone seeking emergency treatment and must stabilize them, regardless of their ability to pay. No patient dumping. That's a statute. As the doctors work, the hospital administrator starts looking into her records. They need to access her medical history, but they can only share it with the people directly involved in her care. Why? Because of another statute, HIPAA, the Health Insurance Portability and Accountability Act of 1996. This is the law that protects the privacy and security of your health information. It creates a national standard, a set of rules for who can look at your medical chart and why. That's a statute. Later, when Maria is stable, the hospital will figure out billing. Let's say Maria has insurance she bought on the marketplace. The reason that Marketplace exists, the reason her plan has to cover essential health benefits and can't deny her coverage for a pre-existing condition they might discover, is because of another landmark statute, the ACA, the Affordable Care Act. These statutes, EMTLA, HIPAA, the ACA, are the explicit commands from our elected representatives. They are the strong, visible framework that dictates the hospital's most critical obligations. But a statute is often just a broad command. Congress can't possibly write down the specific instructions for every single hospital, clinic, and insurance company in the country. So they delegate that task. And that brings us to the third layer of law, regulations. If statutes are the steel beams, regulations are the millions of nuts, bolts, and wires that hold them all together. Regulations are the detailed rules written by executive agencies like the Department of Health and Human Services, or HHS. Congress passed HIPAA, the statute, saying protect patient health information. But it was HHS that wrote thousands of pages of regulations detailing exactly how to do that. The regulations specify the type of encryption a hospital's computer system must have. They dictate the specific training employees must receive. They lay out the precise procedures for how Maria can request a copy of her own records. These regulations have the full force of law. They are incredibly detailed, often mind-numbingly complex, and they govern the day-to-day, minute-to-minute operations of the entire healthcare system. When the hospital follows its privacy protocols for Maria's chart, it isn't just following a good idea. It's following a specific federal regulation, the violation of which could result in massive fines. So we have the Constitution as the bedrock, statutes as the beams, and regulations as the wiring. But there's one more crucial layer, and it's the one that's constantly changing, evolving, and being built in real time. This is the fourth layer. Case law, also known as the common law. This is law made by judges. Let's imagine a tragic turn in Maria's story. During her emergency surgery, the surgeon makes a mistake. A sponge is left inside her. This causes a severe infection, leading to more surgeries and permanent injury. Maria, believing the surgeon was negligent, decides to sue for medical malpractice. Now, there isn't a specific statute passed by Congress that says a surgeon must not leave a sponge in a patient. Instead, this area of law is governed by centuries of court decisions. Her case will go before a judge. Her lawyer will argue that the surgeon breached the standard of care, a legal concept defined by what a reasonably competent doctor would have done in a similar situation. The hospital's lawyers will argue the opposite. Both sides will cite previous court cases, known as precedents, to support their arguments. The judge's final decision, and the decisions of any appellate courts that review it, will become part of the case law. It will be used by future judges in future cases to decide what the standard of care should be. This is a living, breathing form of law, crafted from the facts of real individual human stories like Maria's. Every malpractice suit, every dispute with an insurance company, every legal challenge to a hospital policy contributes to this ever-growing library of judicial opinions that shape our rights and responsibilities. So think about it. In the span of a few hours, one person's tragic accident has intersected with all four foundational layers of American health law. The Constitution gave the government the power to act. Federal statutes like EMTLA and HIPAA created specific duties and protections. Agency regulations dictated the precise operational details of her care. And the potential for a lawsuit is governed by a rich history of case law that defines professional responsibility. It's a breathtakingly complex web. These four sources don't exist in isolation. They constantly interact, influence, and sometimes even conflict with one another. A new statute from Congress can override decades of case law. A new Supreme Court interpretation of the Constitution can invalidate a statute that millions of people rely on. A new regulation from an agency can change the way every hospital in the country operates overnight. Understanding these four sources, Constitution, statutes, regulations, and case law, is like learning the key on a map. It doesn't show you the whole landscape, but it gives you the symbols you need to start reading it. We've looked at the blueprints. We see the foundation and the framework. But a blueprint is just a piece of paper. To create a building, you need people. You need architects, engineers, construction crews, and inspectors. So who are the powerful figures and institutions that draw these lines, pour the concrete, and enforce the rules in American health law? Who are the real players in this high-stakes game that determines the life and death of millions? Well, that's where the power, the politics, and the money really come into play. At the top of this complex food chain, you have the federal government. Think of it as the master architect and the chief engineer for the entire country. It draws the grand, sweeping blueprints. The primary agency holding the pen is the Department of Health and Human Services, or HHS. This is a behemoth, a government department so vast it has a budget larger than the entire economies of most countries. HHS is the command center, overseeing everything from the search for a new cancer cure at the National Institutes of Health to the emergency response of the Centers for Disease Control and Prevention, the CDC, when a new virus emerges from the shadows. Within this massive department, you have some truly powerful players. You've got the Food and Drug Administration, the FDA. They are the ultimate gatekeepers. The FDA is the uncompromising building inspector who shows up to the construction site. They test the steel, they check the wiring, they ensure that every single brick, in this case every drug, every medical device, every vaccine, is safe and effective before it can ever be used on the public. Getting a new drug approved by the FDA is a brutal, expensive, years-long gauntlet. They are the reason you can trust that the pill your doctor prescribes won't hurt you, and their decisions can make or break a $100 billion pharmaceutical company overnight. Then you have the Centers for Medicare and Medicaid Services, or CMS. If HHS is the architect and the FDA is the inspector, CMS is the bank. The really, really big bank. CMS controls the purse strings for Medicare, the health insurance program for Americans over 65, and Medicaid, for low-income individuals. Combined, these two programs cover over 100 million Americans. That's nearly 1 in 3 people. Because of this colossal financial power, when CMS speaks, the entire healthcare industry listens. If CMS decides it will only pay a certain amount for a knee replacement, guess what? Suddenly, every hospital in the country reevaluates what it charges for a knee replacement. Their decisions create ripple effects that dictate the price of healthcare for everyone, even those with private insurance. They are the 800-pound gorilla in the room, and their every move is watched, analyzed, and lobbied. But the federal government isn't the only architect in town. This is the United States, and the 50 states are not just administrative outposts, they are powerful entities in their own right. This is a concept called federalism, and it's at the core of the constant tug-of-war in American health law. The states are like the local zoning boards and city councils. The federal government might create a grand blueprint, say the Affordable Care Act, but the states have a tremendous amount of power to decide how, or even if, that blueprint gets implemented on their streets. The perfect example of this is Medicaid expansion. The Affordable Care Act, a federal law, offered to give states a massive amount of federal money if they agreed to expand their Medicaid programs to cover more people. Seemed like a no-brainer. But it wasn't a command, it was an offer. The Supreme Court confirmed that states had the right to choose. And they did. Dozens of states took the deal, expanding coverage to millions. But many others refused, arguing it was an overreach of federal power, or that they couldn't afford their small share of the cost down the line. The result? A geographic lottery. Your access to healthcare as a low-income adult in America can be radically different depending on whether you live in California, which expanded, or Texas, which did not. 2 different states, 2 entirely different realities, all because of this constant power struggle between the federal government and the states. States also license doctors, regulate hospitals, and run their own public health departments. They are a deeply influential force, creating a patchwork of health laws that vary dramatically from one border to another. Now, if governments are the planners and regulators, the private sector is the group that actually builds the city. And they are, arguably, the most powerful players of all. We're talking about the titans of the industry: health insurance companies, pharmaceutical manufacturers, and massive hospital systems. These are not passive participants. They are multi-billion-dollar corporations with a fiduciary duty to their shareholders. Their primary goal is not public health, it is profit. And they spend staggering amounts of money to influence the laws that govern them. The health sector spends more on lobbying in Washington, D.C. than any other industry. More than defense, more than oil and gas, more than Wall Street. They have armies of lawyers and lobbyists whose entire job is to shape legislation in their favor. They help write the rules. When Congress is debating a new law about prescription drug prices, you can bet that PHRMA, the powerful lobbying group for drug companies, is there in every office making their case. When new insurance regulations are on the table, the insurance giants are there, ensuring the final language benefits their business model. These private entities are the powerful developers who want to build lucrative skyscrapers, and they will do everything in their power to get the zoning laws, the permits, and the tax breaks they need to make it happen. Their influence is a constant, powerful undercurrent that shapes the very foundation of American health law. But what happens when these powerful forces clash? When the federal government passes a law, A state refuses to implement it, and a private company claims the law hurts their business. Who settles the dispute? That's where the third branch of government comes in, the judiciary. The courts, from local district courts all the way up to the Supreme Court, are the ultimate referees. They don't write the laws, but they have the final say on what the laws mean. They interpret the Constitution and the thousands of pages of health statutes. Their rulings can uphold a massive piece of legislation, like the ACA, or strike down key provisions, effectively rewriting the law from the bench. A single 5-4 decision by the Supreme Court can change the healthcare landscape for every single American. They are the final arbiters in the endless battle between federal power, states' rights, and private interests. So you have this complex four-way battle constantly raging. The federal government trying to set a national standard. The states pushing back, demanding local control. The private industry spending billions to protect its profits. And the courts trying to interpret the rulebook as the game is being played. It's a messy, chaotic, and incredibly high-stakes system. But there's one more player in this game. The most important one, and the one that is often forgotten: you, the patient, the citizen, the voter. We are the ones who live in this city they're all fighting to build. Our health, our finances, our very lives hang in the balance of their decisions. So we've identified the players on this vast, complicated chessboard. But how do they actually make their moves? How does a simple idea, a politician's promise to lower drug costs or a public outcry for better care, actually navigate this treacherous landscape and become the law of the land? The journey from an idea to a legally binding rule is a brutal, fascinating, and often hidden process. A gauntlet of power, money, and procedure that few truly understand. And that's the machine we need to look at next. To understand this machine, you first have to understand the fuel it runs on: ideas. A health law doesn't just appear out of thin air in a Washington, D.C. office. Starts as a spark, an ember in the real world. It might be the anger of a family bankrupted by a surprise medical bill. It could be the frustration of a doctor who sees a new treatment tangled in red tape. It might be a breakthrough in a university lab that promises to cure a disease, but needs a pathway to patients. Or just as often, it's the quiet calculation of a pharmaceutical company that sees a new way to protect its patent, its profits. These ideas, these sparks of hope or greed, are everywhere. But an idea on its own is powerless. Just a whisper. To become a law, it needs a voice. It needs a champion. This is the first step into the machine. An idea must be adopted by a member of Congress, a representative or a senator, who is willing to turn it into a formal proposal, a bill. Imagine a freshman congresswoman from Ohio. She just won her election by promising to lower prescription drug costs for seniors. She heard hundreds of stories on the campaign trail. Stories of people cutting their pills in half, skipping doses. That idea, doing something, anything to help them, is now her political fuel. So her staff, a team of young, overworked legislative aides, starts drafting. They research, they consult experts, they write dense, legalistic text that attempts to turn that raw, emotional promise into a functional piece of legislation. Finally, it's ready. Our congresswoman walks to the front of the House chamber and drops the text into a wooden box called the hopper. It's a simple, almost anticlimactic act. But at that moment, the idea is officially born into the legislative world. It's given a number. Let's call it H.R. 503, the Affordable Medicine Act. Sounds official. It sounds important. But the brutal reality is this. At this stage, H.R. 503 has a greater than 90% chance of dying a quiet, anonymous death. Because now, it enters the first great filter. The first kill zone. The committee. Every bill is assigned to one or more committees based on its subject matter. Our bill, H.R. 503, would likely be sent to the Committee on Energy and Commerce, and maybe the Ways and Means Committee because they handle healthcare and tax policy. And this is where the vast majority of legislative dreams go to die. The committee room is a legislative graveyard. Think of the committee chairperson as a powerful gatekeeper, a king on a small, but incredibly important throne. This single person has the almost absolute power to decide which bills even get a hearing. If the chair doesn't like our bill, maybe it conflicts with their own political agenda, maybe a powerful donor from the pharmaceutical industry has their ear, or maybe they just don't think it has a chance of passing, they can simply do nothing. They can let H.R. 503 sit on a list, never scheduling it for a hearing, never allowing it to be debated. It dies not with a bang, but with the silent, crushing weight of inaction. This happens thousands of times every single year. But let's say our bill is one of the lucky few. The congresswoman is persistent. She's built a coalition of supporters. and the public pressure is mounting. The chairperson agrees to hold a hearing. This is the first time the bill is truly tested in public. It's trial by fire. The hearing room itself is an arena. On one side, you have the members of the committee, the politicians, sitting on a raised dais. In front of them are the witnesses. For our bill, you'd see a panel of experts. There might be an economist from a think tank arguing the bill will stifle innovation. The CEO of a major drug manufacturer will be there, in a perfectly tailored suit, warning that the bill will lead to job losses and prevent the development of life-saving cures. They will come armed with data, with charts, with sophisticated arguments crafted by the best PR firms in the country. Their arguments are amplified by a shadow army that has been activated the moment H.R. 503 was introduced. Lobbyists. Washington, D.C. has more lobbyists for the pharmaceutical and health product industry than there are members of Congress. Over 3 for every 1. These are not just people who take politicians out for a steak dinner. They are a permanent, professional, and incredibly powerful part of the legislative machine. They are former members of Congress, former high-level staffers who know the system inside and out. They know every rule, every pressure point, and every person to call. They are flooding the offices of the committee members with their own research. They are meeting with staff, providing talking points to politicians who are friendly to their cause. They are running targeted ad campaigns on TV and social media in key congressional districts, telling constituents that this bill will take away their access to medicine. It is a full-spectrum assault of money, access, and information designed to kill the bill right here, in its infancy. But on the other side of the witness table, you have the bill's proponents. You might have a patient advocate, a mother whose child has a rare disease and whose life depends on an affordable drug. She doesn't have charts or a PR firm. She has a story. Her testimony is raw, emotional, and powerful. You might have a doctor from a rural clinic who sees the human cost of high drug prices every single day. You have AARP, the massive seniors advocacy group, throwing its considerable weight behind the bill. This is the battle that happens inside the committee, a battle of facts and emotions, of money and morality. The members of Congress listen, they ask questions, sometimes pointed and aggressive, sometimes sympathetic. It's all part of the public theater of lawmaking. If the bill survives the hearing, if the chairperson is still willing to move it forward, the next stage is the markup. This is one of the most critical and least understood parts of the process. The members of the committee literally go through the bill line by line and they mark it up. They propose changes called amendments. This is where the real horse trading begins. A Republican on the committee might say, "I could support this bill, but only if we remove this price control provision and add a tax credit for research and development." A moderate Democrat might say, "I'm worried this goes too far. Can we phase it in over 10 years instead of 5? Each amendment is a negotiation. Each change alters the DNA of the original bill. Our Congresswoman from Ohio has to watch as her clean, simple idea gets loaded up with compromises, carve-outs, and exceptions. A section is weakened here to win over a key vote. A paragraph is added there to appease a powerful interest group. The process is messy. It's a sausage-making factory of backroom deals and political necessity. The lobbyists are in overdrive during the markup, working the phones, meeting in hallways, offering last-minute suggestions for amendments to their allies on the committee, trying to water the bill down until it's barely recognizable, or kill it with a poison pill amendment so toxic that even the bill's supporters would have to vote against it. After hours or even days of this grueling process, the committee votes, not on the final bill, but on whether to pass this new, amended Frankenstein version of H.R. 503 out of the committee and send it to the next stage, the full House of Representatives. If the vote is yes, it's a massive victory. Our bill has survived the great filter. It has survived the graveyard where more than 90% of its peers now lie. It's battered, it's bruised, and it looks very different from the simple idea our Congresswoman first dropped in the hopper. But it's alive. It has proven it has enough support, enough political will behind it to be taken seriously. But the gauntlet is far from over. Surviving the committee was just the first battle. Now the bill has to prepare for all-out war on the floor of the House, where every single member will have their say, and where the political gamesmanship gets even more intense. And even if it survives that, a whole other chamber, the Senate, with its own bizarre and arcane rules, is waiting. The Senate. It calls itself the world's greatest deliberative body. And while the House of Representatives is a chaotic arena of 435 people shouting for attention, the Senate is a different kind of jungle. It's smaller with just 100 members, 2 from each state. This means each individual senator holds immense power. And in the Senate, the brakes are much, much stronger than the accelerator. The most powerful brake of all is a word you've probably heard. A word steeped in legislative lore and political combat: the filibuster. Now, when you hear filibuster, you might picture Jimmy Stewart in Mr. Smith Goes to Washington, talking himself hoarse for hours on end, fighting for the little guy. And that can happen. But the modern filibuster is far more insidious. You don't actually have to stand there and talk anymore. The mere threat of a filibuster is enough. It's like a legislative ghost that haunts every major bill. To break it, to force a final vote, you need a supermajority. Not 51 votes, but 60. Getting 60 senators to agree on what to have for lunch is a miracle. Getting them to agree on a sweeping piece of healthcare legislation is like trying to nail Jell-O to a wall in a hurricane. This 60-vote rule is the crucible where most ambitious health laws are either forged into a stronger, more moderate consensus, or melted down into nothing. And no bill demonstrates this brutal reality better than the Affordable Care Act, or ACA. When President Obama and the Democrats began their push in 2009, they had a rare filibuster-proof majority of 60 seats in the Senate. It was a golden opportunity, but it was also a razor's edge. They couldn't afford to lose a single vote. Every single one of those 60 senators became a king or queen. The entire process became a frantic, high-stakes negotiation to keep them all on board. The most intense fight was over the public option, a government-run health insurance plan that would compete with private insurers. For progressives, this was the heart of the bill. It was the key to driving down costs and ensuring true competition. But for moderate Democrats, especially those from conservative states, it was a step too far. They feared it was a backdoor to a single-payer system and that it would kill private insurance companies. The debate raged for months. The White House and Senate leadership twisted arms, they pleaded, they cajoled. But a small group of moderates, led by Senator Joe Lieberman of Connecticut, wouldn't budge. They made it clear: if the public option is in the bill, we will vote no. And with that, the 60-vote coalition would crumble, and the entire bill would die. So, in a painful compromise that infuriated their base, the Democratic leadership stripped the public option out of the bill. It was the first major sacrifice on the altar of the 60-vote rule. But it wasn't the last. To get other reluctant senators on board, deals had to be made. And they weren't pretty. To secure the vote of Senator Ben Nelson from Nebraska, a provision was added that would have the federal government permanently cover the cost of his state's Medicaid expansion, a deal no other state received. It was immediately labeled the Cornhusker Kickback. To win over Senator Mary Landrieu of Louisiana, $300 million in extra Medicaid funds were directed to her state, a deal critics mockingly called the Louisiana Purchase. This is the messy, ugly reality of how health law gets made. It's not a clean academic debate about policy. It's a political knife fight in a back alley, where votes are traded for state-specific funding and pet projects. But it worked. After months of brutal negotiations and backroom deals, they had their 60 votes. In the dead of winter, just before dawn on Christmas Eve 2009, the Senate finally passed its version of the Affordable Care Act. It was a monumental, historic victory. Now the process wasn't over. The House had passed its own version of the bill. Normally, the two chambers would form a conference committee to iron out the differences and create one final bill, which both the House and Senate would then vote on again. But then, less than a month later, the unthinkable happened. A special election was held in Massachusetts to fill the seat of the late Senator Ted Kennedy, a lifelong champion of universal health care. In a stunning upset, a Republican, Scott Brown, won the election. And just like that, the Democrats' 60-vote filibuster-proof majority was gone. They were down to 59. The bill was dead. Or so it seemed. The Republicans now had the votes to filibuster the final reconciled bill. They could block it forever. The entire year-long effort, the painful compromises, the backroom deals, the historic Christmas Eve vote. It all looked like it was for nothing. The biggest healthcare reform in a generation was about to die on a procedural technicality. But in the arcane rulebook of the United States Congress, there is almost always a secret passage, a legislative loophole. And this one was called budget reconciliation. Reconciliation is a special fast-track process designed to make it easier to pass bills related to the federal budget, spending, revenue, and the debt limit. And its magic power is this: a reconciliation bill cannot be filibustered in the Senate. It only requires a simple 51-vote majority to pass. It was the ultimate Hail Mary, but it came with its own set of bizarre rules. The main one is the Byrd Rule, named after Senator Robert Byrd, which says that anything in a reconciliation bill has to be primarily budget-related. You can't just stick any old policy in there. If a provision is deemed extraneous, it can be stripped out. So the Democrats had to craft a plan of breathtaking complexity. Here's what they did. First, House Speaker Nancy Pelosi had to convince her members to do something they did not want to do. Pass the exact same bill the Senate had passed on Christmas Eve, with the Cornhusker kickback and all the other deals they hated. They had to swallow it whole. Then, immediately after, both the House and the Senate would use the reconciliation process to pass a second bill, a package of fixes to the first one. This second bill would strip out the unpopular backroom deals and make other changes the House wanted. Because this package of fixes was a budget bill, it could pass the Senate with just 51 votes, bypassing the Republican filibuster. It was a legislative bank shot off a moving train. It was audacious, it was controversial, and nobody was sure it would work. Republicans called it a flagrant abuse of the rules, a nuclear option to jam an unpopular bill through Congress. But in March of 2010, after one last furious round of political maneuvering, they pulled it off. The House passed the Senate bill, and then both chambers passed the reconciliation package of fixes. The bill, the one that had been declared dead just weeks before, was finally through Congress. Now all that was left was a desk in the Oval Office and the signature of a president. But as we'll see, a presidential signature isn't the end of the story. Sometimes it's just the beginning of a whole new war. And this war wouldn't be fought with filibusters and floor speeches. It would be fought with legal briefs and gavels, in the marble halls of the United States Supreme Court. The moment President Obama signed the Affordable Care Act into law on March 23, 2010, the ink wasn't just drying on a bill. It was acting as a starting pistol. Within minutes, literally minutes, the lawsuits began. Florida's Attorney General, soon joined by 12 other states, filed a legal challenge. The next day, Virginia filed its own. By the end, 26 states, along with the National Federation of Independent Business, were locked in a legal battle against the U.S. government. The central battlefield was a single explosive provision: the individual mandate. This was the heart of the law's machinery. It required most Americans to obtain health insurance or pay a penalty. The logic was simple if controversial. To stop insurance companies from denying coverage for pre-existing conditions, you had to make sure healthy people were in the insurance pool, not just sick people. If only sick people bought insurance, the system would collapse financially. The mandate was the engine that made the whole car run. But the states and business groups saw it differently. They saw it as a breathtaking overreach of federal power. Their argument boiled down to a single powerful question: can the federal government force an individual citizen to buy a commercial product from a private company? Think about that for a second. If the government can compel you to buy health insurance, what can't it compel you to buy? Could it force you to buy a gym membership to fight obesity? Could it force you to buy an American-made car to support the auto industry? Or, as one judge famously asked, could the government force you to buy broccoli? This wasn't just about healthcare. This was a fundamental question about the limits of government and the nature of individual liberty. The challengers argued that if the individual mandate was constitutional, then there was essentially no limit to what Congress could do. The government's defense rested on a powerful and, until then, very broadly interpreted piece of the Constitution, the Commerce Clause. Article 1, Section 8, gives Congress the power to regulate commerce among the several states. For nearly 80 years since the New Deal, the Supreme Court had interpreted this clause incredibly broadly. It had been used to justify everything from federal minimum wage laws to civil rights legislation, arguing that almost all economic activity, in aggregate, affects interstate commerce. The government's argument was that the healthcare market is a massive part of the U.S. economy. When people choose not to buy insurance, they don't opt out of the market. They just shift the costs of their eventual care onto everyone else, in the form of higher premiums and hospital bills. This cost shifting, they argued, was a multi-billion-dollar problem that substantially affected interstate commerce. Therefore, Congress had every right to regulate it by requiring people to have insurance. But the opponents had a brilliant counter-argument. They said the Commerce Clause gives Congress the power to regulate activity, not inactivity. Buying insurance is an activity. Regulating the terms of an insurance contract is regulating activity. But choosing not to buy something? That is the definition of inactivity. They argued that the government was trying to regulate a person for simply existing. For the first time, a major legal challenge was drawing a line in the sand, saying the Commerce Clause, as mighty as it is, cannot be used to compel someone to enter commerce in the first place. As the case, now known as National Federation of Independent Business v. Sebelius, made its way through the lower courts, the country's legal system was split right down the middle. Federal appeals courts in different parts of the country came to completely opposite conclusions. The entire legal and political world held its breath. The fate of a president's signature achievement, and healthcare for tens of millions of people, was now headed for a 9-person showdown at the Supreme Court. In March of 2012, the Supreme Court heard an unprecedented 3 days of oral arguments. The tension was palpable. The court was divided just like the country. For liberal justices were seen as likely to uphold the law. For conservative justices were seen as likely to strike it down. And in the middle, as always, was the swing vote. But this time, the swing vote wasn't Justice Anthony Kennedy. It was the Chief Justice himself, John Roberts. A conservative appointed by George W. Bush, Roberts was now the man in the hot seat. The pressure on him was immense. A decision to strike down the law would be seen as a huge act of judicial activism against a sitting president. A decision to uphold it would risk alienating his entire conservative base. On June 28, 2012, the day of the decision, the world was watching. The initial reports that leaked out of the courtroom were chaotic. Major news outlets, including CNN and Fox News, initially reported it incorrectly, declaring that the individual mandate had been struck down. For a few frantic minutes, it seemed the ACA was dead. But then the full story emerged, and it was a plot twist worthy of a legal thriller. Chief Justice Roberts had done something nobody expected. He began by siding with the conservatives on the main question. He agreed that the individual mandate was unconstitutional under the Commerce Clause. He wrote that the government's argument was unprecedented, and that allowing Congress to regulate individuals from cradle to grave, just because they will someday need medical care, would give the federal government a power it was never meant to have. This was a monumental ruling. For the first time in decades, the Supreme Court had placed a significant, hard limit on the power of the Commerce Clause. For the challengers, this was a massive victory. But it was a victory that only lasted for a paragraph, because then Roberts pivoted. In a stunning move, he said that while the government couldn't force you to buy insurance under the Commerce Clause, it could use a different power to achieve the same result: its power to tax. He argued that the penalty for not having insurance wasn't really a command or a punishment. It was just a tax. If you didn't have insurance, you simply paid a tax to the IRS. And if there's one thing the Constitution is crystal clear about, it's that Congress has the power to lay and collect taxes. It was an act of judicial jujitsu. He used the challengers' own momentum against them. By reframing the mandate as a tax, he found a way to save the law while simultaneously reining in the Commerce Clause. The ACA would survive. The individual mandate would stand. But it would stand on a completely different legal foundation than anyone, including the government's own lawyers, had primarily argued for. The decision was a 5-4 vote, but the coalition was bizarre. Roberts joined the 4 liberal justices to uphold the law, but for entirely different reasons. He joined the 4 conservative justices in limiting the Commerce Clause. In the end, almost no one was happy. Conservatives were furious that Roberts had, in their view, betrayed his principles to save Obamacare. Liberals were relieved the law survived, but deeply unsettled that the Chief Justice had just put a major dent in the Commerce Clause, a legal tool they had relied on for generations to expand federal programs. The ACA had survived its first near-death experience. It was wounded, scarred, and legally transformed, but it was alive. The battle in the Supreme Court was over, but the war was just shifting to a new front. This decision, this clever relabeling of a penalty into a tax, had saved the law for now. But it had also planted a ticking time bomb at its very core, a vulnerability that opponents would seize upon years later in their next attempt to finally tear the whole thing down. That ticking time bomb was the individual mandate's new identity as a tax. Chief Justice Roberts, in his effort to preserve the law, had inadvertently handed its opponents a new weapon. A penalty for not having insurance could be seen as a governmental overreach, but a tax? A tax was something Congress had explicit power over. And what Congress can create with its taxing power, it can also destroy. All it would take was a new Congress and a new president with the political will to do it. And in 2016, that's exactly what America got. The presidential election of Donald Trump, who had campaigned relentlessly on a promise to repeal and replace Obamacare, sent shockwaves through the healthcare system. For the first time since its passage, the Affordable Care Act faced a unified government, a House of Representatives, a Senate, and a White House, all controlled by a party committed to its complete dismantlement. The years of symbolic votes to repeal the political posturing, it was all over. This was real. The fight for the future of American healthcare was about to begin in earnest. The opening salvo was fired in the House of Representatives in May of 2017. The bill was called the American Health Care Act, or AHCA. It was a radical departure from the ACA. It aimed to slash the Medicaid expansion, restructure the subsidies to be based on age rather than income, and eliminate the individual and employer mandates. It would allow states to opt out of protections for pre-existing conditions, potentially sending millions back to the days when a prior illness was a financial death sentence. The process was a whirlwind. The bill was rushed through committees with little public debate. The Congressional Budget Office, the nonpartisan scorekeeper, released a devastating report just before the vote, projecting that 23 million more Americans would be uninsured under the new law. But the political momentum was overwhelming. The bill passed the House by a razor-thin margin of 217 to 213. A celebration was held in the White House Rose Garden. It felt, to the bill's supporters, like the beginning of the end for Obamacare. But it was only the beginning of the fight. The bill then moved to the United States Senate, an institution designed to cool the passions of the moment. And the passions were running hot. Across the country, town halls erupted in protest. Activists, many with personal stories of how the ACA had saved their lives or the lives of their loved ones, descended on Washington. They filled the halls of Senate office buildings, staging sit-ins and confronting lawmakers face to face. The human stakes of this abstract legal and political battle were suddenly impossible to ignore. Inside the Senate, the Republican majority was fragile. With 52 seats, they could only afford to lose 2 votes. And the caucus was deeply divided. On one side were conservatives who felt the House bill didn't go far enough. They wanted a full root and branch repeal. On the other side were moderates from states that had expanded Medicaid, who were terrified of the political and human consequences of stripping coverage from millions of their constituents. Senate Majority Leader Mitch McConnell began a secretive, months-long process of trying to write a bill that could somehow thread this impossible needle. He worked behind closed doors, hoping to craft a compromise that could satisfy both factions of his party. But every time he seemed to solve one problem, another would appear. Every concession to the moderates alienated the conservatives, and vice versa. The pressure mounted. The summer of 2017 became a tense, high-stakes chess match, with the health care of tens of millions of Americans hanging in the balance. After multiple failed attempts to bring a full repeal and replace bill to the floor, McConnell, in a last-ditch effort, pivoted to a new strategy, the skinny repeal. This wasn't a replacement plan at all. It was a bare-bones bill that would simply eliminate the most unpopular parts of the ACA, the individual and employer mandates, and cut funding for preventative health services. The idea was not that this would become law, but that it would just be enough to pass the Senate, allowing them to then open negotiations with the House to hash out a final bill. It was a procedural gamble, a legislative Hail Mary. And it all came to a head in the dead of night on July 28, 2017. The Senate chamber was thick with tension. The vote was tied at 50 to 50, with Vice President Mike Pence ready to cast the tie-breaking vote in favor. The fate of the law came down to one man, Senator John McCain of Arizona. McCain had been a fierce critic of the ACA, but he was also a staunch defender of the Senate as an institution, and he was disgusted by the rushed partisan process. Just days earlier, he had returned to Washington after being diagnosed with aggressive brain cancer, delivering a passionate speech pleading for a return to bipartisanship. Now, in the early morning hours, he walked to the front of the chamber. The room fell silent. All eyes were on him. He paused, looked directly at the Republican leadership, raised his right hand, and gave a firm, dramatic thumbs down. A collective gasp echoed through the chamber. On the Democratic side, there was shock, then quiet jubilation. On the Republican side, stunned disbelief. With that single gesture, the 7-year quest to repeal the Affordable Care Act had failed. By the slimmest of margins, the law had survived its most direct existential threat. But the war was far from over. If you can't repeal a law, maybe you can cripple it. Having failed in their legislative assault, the law's opponents returned to the ticking time bomb left by Chief Justice Roberts: the tax. Later that year, as part of the massive Tax Cuts and Jobs Act of 2017, Congress did something deceptively simple, yet legally profound. They couldn't get the votes to eliminate the individual mandate itself, but they could get the votes to change the penalty for not having insurance. So they changed it to $0. The mandate to buy health insurance still existed in the text of the law. But as of 2019, the financial consequence for ignoring that mandate was gone. It was a mandate with no teeth. This seemed like a clever political solution. It appeased conservatives who hated the mandate, but it didn't technically repeal the law, so moderates could live with it. But what it really did was light the fuse on the legal time bomb. Remember, the only reason the Supreme Court had upheld the mandate in 2012 was because the penalty attached to it could be interpreted as a tax. It raised revenue for the government. But what happens when that tax is set to $0? A tax that raises no revenue, is it still a tax? And if it's no longer a tax, then it becomes just a command to buy a product, the very thing the Supreme Court had said was unconstitutional. Opponents of the law saw their opening immediately. They argued that by zeroing out the tax penalty, Congress had surgically removed the one leg the law had to stand on. And if the individual mandate was now unconstitutional, they would argue, then the entire sprawling, interconnected law, the pre-existing condition protections, the Medicaid expansion, the subsidies, the requirement for kids to stay on their parents' plans, must all fall with it. The stage was set for one more epic showdown at the Supreme Court, a final all-or-nothing battle to determine if the Affordable Care Act would live or die. The case, which would come to be known as California v. Texas, was in many ways the strangest legal challenge yet. The argument was deceptively simple, almost elegant in its audacity. It went like this. Back in 2012, Chief Justice John Roberts saved the ACA by declaring that the individual mandate wasn't a command to buy insurance, but rather a tax on those who chose not to. It was constitutional because Congress has the power to tax. But then in 2017, a Republican-controlled Congress passed the Tax Cuts and Jobs Act. In that massive bill, they did something very specific. They zeroed out the penalty for not having health insurance. They reduced the tax to $0. So the challengers argued if the tax is $0, it's no longer a tax. And if it's no longer a tax, then the individual mandate reverts to being what its opponents always claimed it was: an unconstitutional federal command for a private citizen to buy a product. A ghost of a command, perhaps, since there was no penalty for ignoring it, but a command nonetheless. And here was the knockout blow. They argued that the mandate was so essential to the entire law, the linchpin as the Supreme Court itself had once called it, that if the mandate was unconstitutional, the entire Affordable Care Act had to be struck down with it. Not just the big parts, but everything. The protections for pre-existing conditions, the expansion of Medicaid, the rules allowing young adults to stay on their parents' insurance until age 26, the calorie counts on menus, the funding for public health initiatives. All of it. It was a legal theory that critics called a bank shot, a Hail Mary. The defenders of the law, a coalition of Democratic-led states, had their own powerful arguments. First, they questioned who even had the right to sue. This is a legal concept called standing. To bring a lawsuit, you have to show you've been harmed. But how can you be harmed by a command that has no penalty? If the government tells you to do something but there are zero consequences for not doing it, have you really been injured in a way that a court can fix? It's like a speed limit sign with no police and no fines. It's a suggestion, not an enforceable law. But their main argument centered on something called severability. This is the real heart of the case. Severability is a legal doctrine that asks a simple question. If one part of a law is found to be unconstitutional, can the rest of the law survive without it? The test is to look at what Congress intended. When the 2017 Congress zeroed out the mandate's penalty, they had the chance to repeal the entire ACA. In fact, they had tried and failed to do just that months earlier. So the defenders argued when Congress deliberately chose to eliminate the penalty but leave the other 900+ pages of the law on the books, their intent was crystal clear. They wanted the rest of the law to stand. They had surgically removed the mandate's teeth, not demolished the entire building. To argue otherwise was to ask the Supreme Court to do what the political branches of government could not. The case began its journey in a federal district court in Texas. In December 2018, the judge sided completely with the challengers, issuing a stunning ruling that declared the entire ACA unconstitutional. The decision sent shockwaves through the healthcare industry, the political world, and the lives of millions of Americans who suddenly faced the prospect of losing their coverage. The ruling was immediately appealed, and the law remained in effect while the legal battle continued. The case then went to the Fifth Circuit Court of Appeals. A year later, in a split 2-1 decision, the appeals court agreed with the Texas judge on one point. The individual mandate, now with a $0 penalty, was unconstitutional. But on the huge question of severability, whether the rest of the law had to fall, the court punted. They sent the case back to the lower court, saying the issue needed more detailed analysis. This created even more uncertainty. The law was in a state of legal limbo, declared partially unconstitutional but still fully in effect, with its ultimate fate hanging by a thread. The defenders of the ACA knew this uncertainty was unsustainable. They needed a final answer. And so they appealed to the only place that could provide one, the Supreme Court of the United States. The court agreed to hear the case, scheduling oral arguments for November 2020, just 1 week after the presidential election. The timing was electric. The political stakes were astronomical, and the composition of the court itself had changed dramatically. Justice Ruth Bader Ginsburg, a reliable vote to uphold the ACA, had passed away. Her replacement, Justice Amy Coney Barrett, had previously been critical of Chief Justice Roberts' 2012 decision to save the law. To many observers, it looked like the end. With a 6-3 conservative majority, the ACA's opponents believed they finally had the votes to strike it down once and for all. The day of the oral arguments arrived. The lawyers for Texas and the Trump administration, which had joined the lawsuit against the ACA, laid out their case. They argued that the mandate was the foundation of the ACA's architecture. To remove it was to pull the cornerstone out of the archway. The entire structure was designed to collapse without it. Then came the lawyers for California and the House of Representatives defending the law. They hammered on the issue of standing and severability. They painted a picture of the chaos that would ensue if the court struck down the entire law. Tens of millions losing insurance during a global pandemic, a trillion-dollar industry thrown into turmoil, a decade of American healthcare policy erased with the stroke of a pen. But as always, the real drama came from the questions asked by the justices themselves. And very quickly, it became clear that the case might not go the way everyone expected. The two key votes appeared to be Chief Justice John Roberts and Justice Brett Kavanaugh, and both seemed deeply skeptical of the challenger's argument. Justice Kavanaugh posed a hypothetical. He pointed out that many laws have parts that are unconstitutional, but the court usually just strikes down the problematic section and leaves the rest. He said, "It does seem fairly clear that the proper remedy would be to sever the mandate provision and leave the rest of the act in place." It was a signal that he wasn't buying the all-or-nothing argument. Then came the Chief Justice. He focused on the logic of severability. He said to the challenger's lawyer, "It's hard for you to argue that Congress intended the entire act to fall if the mandate was struck down when the same Congress that lowered the penalty to zero did not even try to repeal the rest of the act. I think frankly that they wanted the court to do that. But that's not our job." It was a stunning moment. The Chief Justice was essentially accusing the challengers of asking the judiciary to finish a political fight that they had lost in the legislature. He was suggesting that Congress had made its choice to gut the mandate but keep the law, and it was the court's duty to respect that choice, not to override it. As the 2 hours of arguments concluded, the conventional wisdom began to shift. It no longer looked like the ACA was doomed. It seemed that at least two conservative justices were unwilling to take the dramatic step of dismantling the entire healthcare law over a single unenforceable provision. But nothing was certain. The justices would now retreat into their private conferences to deliberate and vote. The fate of American healthcare, affecting 1/6 of the U.S. economy and the well-being of nearly every American citizen, now rested in their hands. The nation, in the midst of a pandemic and a tumultuous political transition, would have to wait months for the final verdict. The 9 justices retreated from the public eye, but the legal and political shockwaves from the arguments in California versus Texas continued to ripple across the country. For the third time in less than a decade, the fate of America's most significant healthcare legislation was being decided not in the halls of Congress, but in the quiet, marble-clad chambers of the Supreme Court. The central question was no longer about Congress's power to regulate commerce or to tax. Instead, it revolved around a different, more intricate legal doctrine: severability. Think of it like a game of Jenga. The Affordable Care Act is a massive, complex tower built of hundreds of different blocks. One of those blocks was the individual mandate, the requirement to have health insurance. In 2012, Chief Justice John Roberts had saved the tower by declaring that this specific block was a tax. But in 2017, Congress did something surgically precise. They didn't pull the block out. They just changed its value, its weight, to zero. The tax penalty for not having insurance became $0. The challengers, led by Texas, argued that this zeroed-out mandate was now an unconstitutional command with no tax to justify it. And they claimed this specific block wasn't just any piece of the tower, it was the foundational block. They argued that Congress in 2010 believed the entire structure would collapse without it. Therefore, if that one block was now unconstitutional, the entire Jenga tower, all of it, from pre-existing condition protections to Medicaid expansion, had to come crashing down. The defenders, led by California, countered with a simple but powerful argument. They said, look at what Congress actually did in 2017. They had the chance to topple the entire tower. They could have repealed the whole law. But they didn't. They chose to only neutralize one single block, leaving the rest of the entire structure standing. That action, they argued, was the clearest possible evidence that Congress intended for the rest of the law to survive. The tower was designed to stand even without that one piece. While lawyers debated these abstract architectural principles, for more than 20 million Americans, this was not a game. It was their life. The threat wasn't a collapsing tower of wooden blocks, but the implosion of a healthcare system they had come to rely on. For a person like a freelance graphic designer in Arizona with a heart condition, the ACA's marketplace and its protections against discrimination based on pre-existing conditions weren't just a policy. They were the only reason she could afford the insurance that kept her alive. The arcane legal debate over severability translated, for her, into a single terrifying question. If the court sides with Texas, will I be able to afford my medication next year? Will any company even sell me a plan? For a 24-year-old recent college graduate in Ohio, working an entry-level job without benefits, the ACA meant he could stay on his parents' insurance plan. It was a bridge, a safety net that allowed him to start his career without the crushing fear of a medical bill from a sudden illness or accident wiping out his savings. The legal arguments in Washington, D.C. were a world away, but a decision against the law would yank that safety net out from under him overnight. And for a single mother in Louisiana working 2 part-time jobs, the state's decision to expand Medicaid under the ACA was life-changing. For the first time, she had access to regular checkups, to preventive care, to the ability to see a doctor when she felt sick without having to choose between her health and paying her rent. The potential elimination of the law threatened to send her and millions of the nation's most vulnerable citizens back into a world where the emergency room was their only form of primary care. A system that is devastating for patients and catastrophically expensive for everyone else. The waiting period was agonizing. Months ticked by. Winter turned to spring. The new Biden administration entered office and immediately tasked its Department of Justice with reversing the government's position, aligning the United States with California and the other defenders of the law. But the case was already in the hands of the court. The pandemic, still raging, added a horrifying new layer of urgency. Millions of Americans had lost their jobs and their employer-sponsored health insurance, making the ACA's marketplaces a more critical lifeline than ever. Furthermore, COVID-19 itself was creating a massive new population of people with a pre-existing condition. Survivors dealing with long COVID, lingering respiratory, neurological, and cardiac issues faced the terrifying prospect that if the ACA fell, they could be deemed uninsurable for the rest of their lives because of a virus that had already taken so much. Finally, on June 17, 2021, the wait was over. The Supreme Court issued its ruling. The news spread like wildfire. The Affordable Care Act had survived. Again, the vote was 7-2, a decisive majority. But the reason for the decision was a complete surprise, a stunning legal plot twist that no one had fully anticipated. The justices didn't rule on the central question of severability at all. They didn't decide whether the Jenga tower could stand without its foundational block. Instead, they dismissed the case on a different fundamental legal principle, standing. In the American legal system, you can't sue someone just because you don't like a law. To bring a lawsuit, you have to prove that the law has actually harmed you in a concrete way. This requirement is called standing. The court, in an opinion written by Justice Stephen Breyer, concluded that the states and individuals challenging the law couldn't prove they had been harmed. Their entire argument rested on the idea that the individual mandate, now with a $0 penalty, was an unconstitutional command that was injuring them. But the court essentially asked, how can you be injured by a command that has no penalty for disobeying it? If there's no fine, no tax, no consequence whatsoever for ignoring the mandate, then there is no harm. And if there is no harm, there is no standing to sue. It was a brilliant legal sidestep, The court had found an off-ramp, a way to dispose of this politically explosive case without having to rule on the bigger, more divisive questions about the law's constitutionality or the intent of Congress. They didn't have to decide if the tower would fall, because they ruled that the people trying to push it over had no right to be in the courtroom in the first place. The challenge was thrown out on a procedural technicality, not on its merits. For the millions of Americans whose healthcare hung in the balance, the reason didn't matter as much as the result. The law was safe. The marketplaces would remain open. The protections for pre-existing conditions were secure. Medicaid expansion would continue. A collective sigh of relief was felt across the nation. The ACA had once again faced an existential threat in the highest court in the land, and for the third time it had emerged, battered and bruised but intact. Yet, the nature of the victory was telling. It was a victory by dismissal, not a ringing endorsement. The court didn't declare the ACA constitutional for all time. It simply said that this specific challenge was invalid. This pattern of surviving by the skin of its teeth, often on narrow or technical grounds, had become the defining story of the law itself. It highlighted a profound reality of American health law, that our most important policies are not just shaped by grand debates in Congress, but by the intricate, often anticlimactic application of legal doctrines like commerce, taxing power, severability, and standing. The ACA had survived its latest near-death experience, but the narrowness of the ruling was a stark reminder that in the perpetual battle over the soul of American healthcare, the war was far from over. The next legal challenge, the next political assault, was always just around the corner. And that corner was turned faster and more dramatically than anyone could have imagined. The next challenge wasn't just another lawsuit or a piece of legislation debated in the halls of Congress. It was a microscopic spiky ball of protein and RNA that would bring the entire world, and the American healthcare system, to its knees. The COVID-19 pandemic wasn't just a public health crisis. It was a crucible for health law itself, a real-time, high-stakes stress test of every principle, statute, and precedent we've discussed. Suddenly, abstract legal concepts became front-page news, debated at dinner tables across the country. The power of the state to protect public health, a principle established over a century ago in Jacobson v. Massachusetts, was no longer a historical footnote. It was the legal justification for lockdowns, for mask mandates, for closing businesses and schools. The tension between individual liberty and the collective good exploded into a full-blown culture war. Where does a governor's emergency power end, and an individual's right to assemble or conduct business begin? These weren't theoretical questions anymore. They were being litigated in real time, with life or death consequences hanging in the balance. The pandemic also supercharged a technological revolution in healthcare delivery. Before 2020, telehealth was a niche concept slowly gaining traction. Overnight, it became a necessity, but this rapid shift created a legal and regulatory vacuum. How does a doctor licensed in Texas legally treat a patient who is temporarily in California? How do we ensure patient privacy under HIPAA when consultations are happening over commercial video conferencing apps? Federal and state governments scrambled to issue emergency waivers, relaxing long-standing rules to ensure continuity of care. But now, as the dust settles, we're left with a patchwork of temporary fixes. The great challenge of post-pandemic health law is to build a permanent, secure, and equitable legal framework for virtual care, one that balances convenience with quality, access with privacy. And while the pandemic raged, other foundational pillars of American health law were being shaken. In 2022, the Supreme Court's decision in Dobbs v. Jackson Women's Health Organization overturned nearly 50 years of precedent established by Roe v. Wade. This didn't just return the question of abortion to the states. It unleashed a legal firestorm, creating a chaotic and deeply fractured map of healthcare access. Suddenly, the simple act of crossing a state line could determine a person's fundamental reproductive rights. This has ignited a new wave of legal battles over interstate travel, data privacy for period tracking apps, and the role of the Emergency Medical Treatment and Labor Act, or EMTLA, in requiring hospitals to provide emergency abortion care regardless of state law. The conflict has even reached into the heart of the Food and Drug Administration's authority. The battle over mifepristone, a medication used for abortion, isn't just about reproductive rights. It's a fundamental challenge to the FDA's scientific, evidence-based process for approving drugs. For decades, the FDA has been the gold standard for drug safety and efficacy. But now we see legal challenges seeking to have judges, not scientists, overturn approvals for medications that have been on the market for over 20 years. The implications of this are staggering. If a court can unilaterally revoke the approval of one drug based on ideological grounds, what's to stop it from doing the same for vaccines, contraceptives, or any other medication that becomes politically controversial? It's a direct assault on the very concept of a national, uniform system of drug regulation that protects all Americans. At the same time, the economic pressures on the system continue to mount, leading to new and audacious legal reforms. For years, the idea of the U.S. government negotiating drug prices with pharmaceutical companies was considered a political impossibility. The industry's legal and lobbying power seemed insurmountable. Yet, the Inflation Reduction Act of 2022 did just that, empowering Medicare to negotiate prices for some of the most expensive drugs on the market. And predictably, it was met with an immediate hailstorm of lawsuits from pharmaceutical giants. They argue that the law is unconstitutional, that it constitutes an illegal taking of their property and violates their due process rights. This legal fight is about more than just the price of a few specific medications. It's a titanic struggle over the government's power to control healthcare costs and regulate one of the most powerful industries in the world. The outcome will shape the financial reality of American healthcare for generations. So where does this leave us? After this journey through a century of law, politics, and human drama, what is the ultimate importance of health law in the United States? It's this: health law is the architecture of our empathy. It is the blueprint we design as a society to care for one another in our most vulnerable moments. It is the set of rules that determines whether a sick child's family goes bankrupt, whether a new mother survives a difficult childbirth, whether an elderly patient can afford their life-saving medication. It is a living, breathing entity, constantly being shaped and reshaped in courtrooms, in legislative chambers, and in the voting booth. It is not some dusty academic subject. It is the fierce debate over vaccine mandates. It's the quiet revolution of a telehealth appointment. It's the desperate search for care across state lines. It is the legal battle that determines the price of the pill you take every morning. The story of health law is the story of a nation perpetually grappling with its own identity. A nation that champions rugged individualism, but also recognizes the need for a collective safety net. A nation that pioneers breathtaking medical innovation, but struggles to deliver it equitably to all its citizens. It is a story of conflict, of compromise, and of the relentless, often messy, pursuit of a more perfect union, where the promise of life, liberty, and the pursuit of happiness includes the fundamental right to be healthy. Understanding this field isn't about memorizing statutes or case names. It's about understanding the forces that shape your life, your family's life, and your neighbor's life. It's about recognizing that every healthcare headline, every political debate, every personal struggle with the system is a part of this larger, ongoing narrative. The law is the battleground, but the stakes are deeply human. And in a world of ever-increasing complexity, from global pandemics to genetic engineering, the need for a just, equitable, and compassionate legal framework for health has never been more critical. The story is far from over. And because it affects every single one of us, we all have a role to play in writing the next chapter.